Picture this. You walk into your local gun store like you've done before. You pass the background check. You follow every rule. You're a law-abiding citizen. But this time, the clerk shakes their head and says, "Sorry, that firearm is banned in this state." Now imagine a court just ruled that ban might not actually hold up under the Constitution. So here's the question that's got people across the country paying attention. Could some gun bans in the US actually be on shaky legal ground right now? A recent federal court decision is stirring up serious debate, and it could have real consequences for how gun laws work moving forward. Let's break it down in plain English. At the center of this is a federal appeals court ruling that looked at a specific type of gun restriction, laws that ban certain firearms, often labeled as assault weapons, or restrict high-capacity magazines. These laws exist in several states and have been controversial for years. What the court basically said is this: when the government limits someone's Second Amendment rights, it has to prove that the restriction fits within the historical tradition of gun regulation in the United States. In simple terms, if a law today doesn't match the kind of rules America had back when the Constitution was written, or something very similar, it might not pass constitutional review. That idea comes from a major Supreme Court decision in recent years that changed how courts evaluate gun laws. Instead of balancing safety concerns against gun rights, courts now focus heavily on history. They ask, was there a similar law back in the 1700s or 1800s? And that's where things get interesting. In this new case, the court found that the government didn't show enough historical evidence to justify the ban they were defending. So the law was struck down, at least for now. That doesn't mean all gun bans are gone overnight, but it does mean some of them could face serious challenges moving forward. Think about what that means for a second. If courts continue applying this same standard, more gun laws could be questioned. States might have to defend their rules in a completely different way than before. Let me ask you something. Do you think laws today should be judged based on what existed over 200 years ago? Or should modern safety concerns carry more weight? That's really the heart of this debate. Now let's talk about what this actually means for everyday people. If you're a law-abiding gun owner, this could expand access to certain firearms that were previously restricted, depending on where you live. Laws that once blocked certain purchases might not survive legal challenges. But, and this is important, nothing changes instantly. These cases take time. Appeals happen. Different courts can reach different conclusions. So right now, it's more like a legal shift in motion, not a final answer. If you're someone concerned about public safety, this ruling might feel unsettling. Critics argue that limiting certain weapons is necessary to reduce mass shootings and protect communities. They worry that relying too much on historical comparisons ignores modern realities, like the scale and technology of today's firearms. On the other hand, supporters of the ruling say constitutional rights shouldn't change just because times change. They argue that the Second Amendment protects individuals, and that the government shouldn't restrict that right without strong historical justification. So you've got two powerful ideas colliding here: individual freedom and public safety. And the courts are now the ones trying to draw that line. Here's another angle to think about. If courts require historical proof for gun laws, what happens when there's no clear historical match? Back in the 1700s, there were no AR-15 style rifles. There were no high-capacity magazines. So how do you compare modern technology to something that didn't exist? That's one of the biggest challenges judges are facing right now. Some say you look for similar regulations, like limits on dangerous weapons at the time. Others say if it didn't exist back then, the government has less authority to regulate it today. This is why different courts across the country are starting to disagree with each other. And when that happens, it often means one thing: the Supreme Court may eventually have to step in again. So yes, this decision is a big deal, but it might just be one chapter in a much longer legal story. Let's bring it back to real life for a moment. Imagine you live in a state with strict gun laws. Over the next few years, those laws could be challenged in court. Some might stay, some might fall. It creates uncertainty, not just legally, but practically. Retailers, law enforcement, and everyday citizens all have to adjust as the rules evolve. And if you're someone who doesn't follow legal news closely, you might suddenly hear, "Hey, that law changed," without really understanding why. That's why decisions like this matter. They shape the rules that affect daily life, even if you're not thinking about them every day. Now I want to hear from you. Do you think this court got it right? Or do you think modern safety concerns should allow stricter gun laws, even if history doesn't match perfectly? Drop your thoughts in the comments. I'm really curious where you stand on this, because this isn't just a legal issue. It's a question about how we interpret rights in a changing world. Before we wrap up, here are 3 simple takeaways. First, courts are now using history as the main test for gun laws, not just balancing safety and rights. Second, this new decision suggests some existing gun bans could be vulnerable to legal challenges. Third, nothing is final yet. This is part of an ongoing legal shift that could eventually reach the Supreme Court again. And here's the final thought to leave you with. If the Constitution stays the same, but the world keeps changing, how should the law keep up? Let me know what you think.